Hello, glad you're back. And if this is the first video you've watched, I hope you'll catch up at the end and you'll be able to watch several others that we have on some educational topics. Try to go real quick. So today we're going to talk about the basics of probate. Now, some of you have had horror experiences with probate, so I even say the word and you want to start doing this and backing up. Some of you have not experienced probate, but it's just kind of the scary term and you don't really know what it is. We're going to go through just some of the basics of probate. Now, everybody has a little different situation on whether you had a will that had to be probate. In my world, you have absolutely nothing that you have not passed out outside of the will, so there's nothing to probate. But ask me if everybody's world is perfect. Now, the answer is no, but that is one of the goals that I have with my clients, to avoid a lot of these cost processes, and then also the length of probate, which in some jurisdictions, I've seen it drag on for decades because of poor estate planning and can't find heirs. So if we can avoid that, I really strongly recommend that we do it. One of the first questions I always get asked from the clients I'm working with is, well, how much does probate cost? Well, that's a great question. And it all depends on how well the estate was planned, how big are the assets that are within the estate. Did you have a will? Did you not have a will? Did you have a poorly drawn up will? Did you really have an outdated will? And the items that are even listed in it don't exist anymore. There are so many variables that can go with it. But if I have to just pick something, I usually tell clients realistically, whether the attorney charges by the hour or they charge a percentage of the estate, it's going to vary widely. But I say at a minimum, plan on 5 to 7%. I said at a minimum. It may be a little more, it may be a little less. That is a good average. And we all know that that is just the difference between a couple of different extremes. Now, what can vary with some of that is the state or the jurisdiction that you live in, if you happen to live in a territory, or if you have assets that are held abroad. You could have a probate process that's going on in the US and a probate process that's going on in Spain that are completely independent of each other. Now, the size of your estate, again, if I have, for example, if I have a very modest estate, if my estate is only $50,000, there may be streamlined probate processes, so where it would be very nominal, maybe only a couple of $1,000s to settle it. On the other hand, what if I have a $2 million estate? We'll do some quick math. $2 million at 5%, that's $100,000. If it is 7%, it's 140. It could be more than that because of some of the things that may be involved in distributing that estate and the valuation of it. Now, how complicated is your estate plan? That's going to have a huge bearing on what it costs to execute the wishes that you have already put down. And what about the wild card here? What do you think happens to the bill when somebody contests the will? They don't like it. They don't like what it said. They didn't get a big enough piece. Something's wrong. I am not being fairly treated. I'm going to sue. Anytime you have someone that contests the will or any part of it, you're going to lengthen the process and you're going to increase the costs. In some cases, all they really want is a bigger check. And sometimes concessions or agreements are made in order to move this process along, whether it tastes good to you or not. Again, you're going to have legal counsel and advice, because contesting it could bring and drag a process out for years with court dates or anything else and increasing the costs. So what does that cost? I don't know. It all depends on how long you want to drag that particular process out. Some things are going to be relatively consistent as far as costs go. It may just be a quantity issue. So, for example, if you're doing some filing fees, when you initially file it, well, you're generally only going to file it once. I have seen some states that the filing costs are as little as $50. I've seen others that go well over $1,000 just for the filing of the documents. And then when we get past that, one of the other costs can be any type of certificate fees, or if we have to have notarized documents, if we've got to have letters prepared, sent in, It all depends on the institution you may be dealing with. If you get a copy of a death certificate, I assure you, one is not going to be enough. You may have to have 10 or 20. Again, I don't know how complex the estate is, but if you had to have 20 original certified death certificates and they are $20 each, well, that's $400 plus whatever the cost was for someone to get those, gather them up, and then the time to prepare the letters or fill out the forms to send them in, it goes on and on. So that's just, for the copies that you may need, or if you've got to get notarized documents. What if you have 4 people who have to notarize a document, all for the same account? Again, it can vary a little bit. So those are ones. Here's another one for you that's common, and it depends on what's written. If you have an executor, and you will have an executor, does it say that the executor will be compensated or not? Generally, the executor will, as a matter of routine, be reimbursed for their expenses, whether that is travel expenses in order to deal with estate issues. It can also be having to seek legal counsel. And if they ended up paying it out of their pocket first, whatever the case may be, there's usually going to be expenses by the executor that need to be reimbursed. And how much are those? It all just depends. It depends on what they're spending out of their own pocket that needs to be reimbursed from the estate. Do they need a surety bond? I don't know. That also can depend on what's written into the will. Now, what's written into the will, of course, if they have to have a surety bond, then the estate is going to pay for that in addition to that. And again, the question I get, well, what's a fair compensation for an executor? That's a really good question. How much does this person normally make so that if I had to take 2 weeks off of my job in order to go handle estate issues, and I don't want to use my vacation, or I don't have vacation, is it fair for that person to use all of their time for free, or should they be compensated? Should they be compensated at least what they would have made at work? That's not unreasonable. Some of them will also be allowed to do a percentage of the estate. Depends on your jurisdiction. But if the jurisdiction said that they were entitled to 3 to 5% of the estate, even if that would exceed what their wage was at a job, that's still not an unrealistic compensation. Realize that if you are named as an executor, for some of you, this is going to feel like a full-time job. You're going to be doing it nights, weekends, lunch hours, holidays, regular days. And so it is not unreasonable, in my opinion, for the executor to be compensated, because they often have a huge time investment that the rest of the heirs do not experience in order to settle the estate. So what does that cost? It's really unknown until you actually get there. What are some other things that can add up to the probate process and the fees? An appraisal. What if we have 6 different properties? They're rental properties. Just choose something. Maybe one of them is the family home. And the will is leaving it up to the executor to pass out assets as equitably as possible. Well, we all know they don't all have the same value. We may have to order appraisals in order to determine what the properties are worth to come up with a way to pass them out. Maybe each individual gets 1 property and some cash. So we would have to have an appraisal in order to be able to know what each property is worth, to be able to know how to distribute those particular properties, and with the discretion. The other thing that I'm going to say for long-term planning, even if you were to get the property, you want to have as the recipient a copy of that appraisal, because that becomes, under current law, when this is being filmed, your basis. If you decide to sell that property, you're going to need to know what the basis of the property was at the time of your inheritance, so that you can determine on your tax return whether you have a capital gain or a capital loss. If it was a rental property, for example, you're going to have to put something down for a depreciation basis. So you need that. It is a normal part of estate settlement. It's going to depend on how many items need to be appraised for a value. Don't discount postage fees and delivery fees. Is it important for you to use overnight or priority mail or something for every envelope? Do you want to have signature receipt so that they've got to sign for it? All of those things add up, plus the time to go to the post office to do it. And see, all of these things add up because somebody has to put the package together. Somebody's got to mail it. Somebody's got to do the postage. All of those things can add up, and individually they may be not too large, or they could be extremely large, depending upon how many pieces that we have to treat this way. Do you own a business? Yeah. Do you need a business valuation? What's the business worth? How do you have that taken into place? Now, there are other places that I will talk about buy-sell agreements for death or disability. This is really important that we have a process in place for a business valuation, depending upon how you're going to pass that out. Can we spend a minute and talk about business valuation fees? Yes, some of you have a business. Now, on your business, many of you, or at least you should, because I certainly stand on this soapbox a lot, you should have a buy-sell agreement for death or disability. And of course, we're talking about probate. So in this case, it's going to be from death. Now, on the business valuation, we need it again for a cost basis, but it also may need to be sold or divided. Something is going to happen with it. So a business valuation, how much does that cost? Well, it depends on the business and who is doing the valuation. The other thing this is going to take is time. It's going to have to be paid for. A business valuation can run several $1,000s very easily. Oh, you own 5 businesses? Well, that will be for each business. So you see that there is a cost there, which we don't know what it is, depending upon how you have set things up. Now, along with the business valuation, I just did a video recently. I don't know if it's up yet. If you're watching this one, I talked about digital assets. Now, for many of you, when you're not even thinking about what the value of your digital assets are, whether they are personal or business, or if you've got online stores, you've got books, whatever the case may be. So don't forget that depending upon how you have set up or not set up your digital assets. Now, that is a new asset class for many of you that may need a valuation that really didn't exist, 10, 20 years ago. You didn't even think about it. So don't forget that there can be a wild card on the digital assets. And did you put in your documents who is to receive those digital assets, or who are they to be sold to? So just throwing that out. In business, it's a whole new world when you start thinking about digital assets. Do you have any notary fees? Well, it isn't a whole lot. Depends. Now, if you're working with a law firm, they may do that in-house. In the jurisdiction that I live in, they were very excited because they finally raised the fee to $10 a page. It's not a lot. But again, it's an additional fee that you may have to have in a state settlement with the probate. What about storage fees? Did we vacate a property? Did we close something down? Where do we put the stuff? When we're in the middle of a sale. So some of you may have storage fees, whether the storage fees are for records or they're for personal possessions. For example, if you had a business, you may be required or you may need to maintain all of the business records for 5 to 7 years, even if you sold the company, because of the tax-related issues that go along with it. Well, where are you going to put them? Depends upon the size. So you could have storage fees and things that could deplete the estate and also be part of the probate process that you hadn't thought about. What about estate sale prep fees? Maybe you're going to have a great big auction and you're going to bring a company in who's going to dispose of the family farm and everything that's been in it for, the last 7 generations, because there's no one who's going to take that over. Well, there's going to be costs involved with that and getting things ready. If you're going to sell a property, there could be costs to get a property ready to sell or cleaned out and those type of things. So you can have all of that. And of course, there's much more that can fall into this category because, again, each estate could be unique or not. There could also be jewelry. Do we have a lot of jewelry that we have to go back, and maybe it's to be divided between individuals, because trying to treat individuals or beneficiaries equally can be a very difficult thing to do when you're looking at property, which could be houses, it could be cars, it could be paintings, digital assets, it could be jewelry, whatever the case is. And if I'm the executor and I'm in charge of, and they've given me the discretion, which is frightening in some ways too, because you're not going to keep everybody happy. It's not going to happen. To pass out the assets. All right, well, you get grandma's diamond ring, and you get, this number one rental property, and you get $400,000 in CDs. The next person wanted more jewelry. All right, you got $200,000 in jewelry. You didn't get a house, and you're going to get one half of the business. So those type of things can, add to the complexity of it. Now, I want to circle back a little bit, and you'll see this on another one of the videos that I have about the titling of your assets. Based on the titling of your assets, that will also determine what, if anything, goes through the probate process. So in many cases, in my perfect world, I really want you to have virtually nothing or very, very little that needs to be probated for the enormous cost savings and also to streamline. And again, these are conversations that you need to have with a financial planning professional. You need to have with your attorney so that you set up the right tools. And in most cases, the tools are the right documents and the right titling of assets to avoid a lot of the things that we have been talking about for the last several minutes. For example, I could have a $200,000 bank account. It's my savings, CDs, whatever it is. It's cash on hand. If I don't have POD, which is pay on death, on the account, which I can do for free, that $200,000 will become part of the estate, and it goes into the estate. Nobody can touch it. Got to go through all the channels. However it's going to be spent, creditor claims, I got to pay a $25,000 credit card bill. I had medical bills, whatever the case is, can all be used out of that $200,000. Remember, I mentioned, 5 to 7% or more. So that $200,000 could greatly shrink before it is ever available to pass out to heirs. If I had it as POD, that money would pass to whoever were the beneficiaries that I had named in the percentages. It is never subject to creditor claims. It never goes through the probate process. It's very neat and clean. Is that the best option for you? Maybe, maybe not. It depends on what you're trying to accomplish and what you need to accomplish. I may want the $200,000 to go into my estate to pay off the $200,000 mortgage so that my heirs can receive the property free and clear, or they can put it up for sale and dispose of it, and there's no mortgage involved. So the answers from one household to the other can be a little different, but you want to make it all part of that coordinated plan. So I'm going to go back to the wish list. When I look at my assets, what do I wish would happen? And then I can design my process so that items that I want to pass outside of probate, I put the right tools in place for that to happen. And items that I want to go through probate, then I have structured them so that's what will happen, but I still want the most efficient process to go through the probate process to keep the assets intact as much as possible, decrease the fees, and then also decrease the amount of time that's involved. Now, we are always, open to additional topics from those of you who are, reach out to us and watch. So by all means, if you've got an idea, please reach out. Tell us what you'd like to see a video about. And in the other side, if you've enjoyed this, if you've learned something, please click the like button for me. If you would subscribe, that's even better. Sharing and caring is a wonderful thing. So by all means, click the subscribe button, like the video, put into practice some of these things I've done here, and feel free to reach out at any time. Thanks for joining me. I look forward to seeing you on another video soon, and I do my best to be a blessing. Have a wonderful day.